Hello, everyone. Hope you had a nice lunch, and welcome to this session, Dialogue on the Friction Between Modern Marketing and Advertising and the GDPR and Eprivacy Directive. Is there an effective way forward? We are very honored that you are here in this session. We believe this is a very important conversation, and we're very honored that you're here for what we expect to be an exciting and substantive discussion on the future of marketing and advertising in the digital age. I'm Sheila Colclasure, Chief Data Integrity and Public Policy Officer at Interpublic Group, and I have the enormous pleasure of moderating and timekeeping this discussion among a panel of extraordinary thought leaders. We have pulled together perspectives across disciplines. Our expert voices are from European business, European research, global brand advertising trade, and European data protection regulator. Our format today will be introduction and opening point of view from each of our thought leaders, followed by curated questions to really bring out the dialogue, and time at the end for questions from all of you. So as we work through the content, please capture any questions you have, so we'll have an exciting, if not rowdy, Q&A session towards the end. Those of us that are practitioners in the space of operational privacy and data governance for many, many years, we've navigated through a lot of change. We've governed through a lot of change, but nothing so extraordinary as the last few years. The observational nature of the internet has taken data-driven marketing and advertising to a new and transformative level, and especially what we call the pandemic pivot. Research says that we did in 1 year what we were on course to do in 5. So the entire business and government and nonprofit and NGO community adopted and pivoted very, very quickly so we could all survive and stay in business and stay connected. It drove us into the digital age faster than we could have even imagined. As the economy becomes ever more connected or digital, so do people, so does business, so does marketing and advertising. The European Charter of Fundamental Human Rights has 54 rights. Articles 7 and 8 relate to privacy and data protection. Article 16 relates to the right to conduct business, which depends on efficiently marketing and advertising to attract and retain customers. Yet there is a great deal of friction between the need to attract and retain customers and the GDPR and the Eprivacy Directive, perhaps even a tectonic collision between those two market forces. Are there ways to reduce the friction of these tectonic forces in a manner that services the full range of rights and interests? Is there a way to throw out the bathwater without throwing out the baby? Is there an effective way forward? We will attempt to tackle these issues in this session. Now I turn to my panelists for their introduction and perspective. Dale, may I start with you?
Thanks very much, Sheila. Thanks for the opportunity to participate in the panel. And what a topic. I'm not sure whether we'll get to solutions, but we can certainly do our best. I want to try and today, as representing the Irish Data Protection Commission, give a regulator's position, our view on the matters that we're discussing. So unquestionably, there's huge friction within this ecosystem of modern marketing, advertising, both in online and how offline interacts with it. Extraordinary, and it's been a huge discussion point and focus point for a number of years now as to when we look at it through the regulatory prism of what in a European context European legislative requirements mean in the context of digital advertising through the Gdpr and the Eprivacy Directive. We've seen a number of actions taken by data protection authorities, particularly in the privacy space. We've seen even, you'll all be familiar with the decision here by the Belgium authority in relation to the TCF. There's appeals up to many of those decisions. There's pending cases before the Court of Justice. There's the recent DPC's decision in respect of Meta and reliance on contract. And across Europe, much is happening in the regulatory space, which is scrutinizing how companies try to comply with the law. And I think it's fair to say this is a massively complex ecosystem. Regulators are, I think, at their doing their utmost to try and understand it. Perhaps there's still some deficit in that front. It is hugely complex. And I think it's, my initial point is that there's no immediate bottoming out from a regulatory point of view in terms of where the final position is on lots of these questions. And ultimately, the courts will deliver on that. And for example, the DPC also has 5 very large ongoing investigations at the moment, which will continue to deliver further landmark decisions. So much regulatory and judicial clarity yet to come. And we have the broader context too of the DMA, the DSA AI impacts on the ecosystem, the impact of new technologies, particularly AI, potential evolution away from use of cookies. There's all sorts of different views on that. There's concerns perhaps around moving away from one technology introduces a technology which is a more adverse impact, such as fingerprinting, so on. There's a certain viewpoint, of course, in general discourse that digital advertising is not inherently compliant with EU legal requirements, and there is also a sense by some that find that just that constant tracking as maybe being somewhat refer to it as being creepy and can't be avoided. And I suppose that reflects issues to do around the place the fundamental rights have in a European context. It reflects, I suppose, issues around our own individual freedom and autonomy to make choices. But I think from a regulatory perspective, it's really important to remember that neither the GDPR nor the Eprivacy Directive, but its focus is obviously slightly different, explicitly prohibit an ecosystem and the profiling and use of data in that ecosystem. Yes, there's certainly questions around how industry complies with those legal requirements, and there's a standard to be adhered to, but I think it's important to remember that regulators regulate in the context of what the law requires, and we do that on a case-by-case basis, looking at the facts of every case, coming to determinations. And equally, it's for companies then to obviously meet their obligations and to seek to continually work towards ways that use data, strike that balance in the use of data without, in a way that minimizes and mitigates the adverse impacts on individuals. So in essence, that's what the GDPR is about, in my view. It's this whole question of proportionality and fairness and striking the right balance. And this is not to make judgments on, or broad judgments on the digital advertising ecosystem, but just to say within this debate, we have to maintain, and as we do as regulators, where does the proportionality and balance lie in all of this in the context of the laws that we have to regulate against. And I just very briefly, because I know I'm running probably over on my time, but I just want to call out the concept of fairness under the GDPR, under Article 5.1a. It's a really essential element of the principles of data protection. Unlike lawfulness and transparency, it's not given, maybe you say, further effect by other provisions of the GDPR, but it's really important to remember that when we look at data usage and in this space as well. What is fairness, and how does an organization or an industry look at this concept of fairness? And we can maybe go into that a little bit later on, but it brings in transparency, it does bring in lawfulness, but it also brings in data protection by design, the principles of data protection, data minimization, etc., bias on adverse consequences for individuals. So I'm going to stop on that point, Sheila, but I just wanted to, as a scene setter, say there's lots of work underway, there's still lots to be bottomed out on, but within that context, I think there's a real need to consider the whole question of what is fair data processing and what needs to change to make sure that we work towards much better standards of data protection where users are at the center of that, that equation.
Thank you, Dale. The F word that really matters, fairness. Paul?
Thank you, Sheila. Paul Breitbarth. I'm data protection lead at Catawiki. I'm co-host of the Serious Privacy podcast, teach at Maastricht University, and I'm a member of the Jersey Data Protection Authority. And I want to make clear that I'm speaking on my own account here and not on behalf of any of the organizations that I'm affiliated with. Some may agree with my position, some may not. You may not even agree with my positions. I don't know if that's why you invited me. Digital marketing is important, certainly for mid-sized companies like the one that I work for on a daily basis. We are an online company. We find our customers online, so we cannot do that without digital marketing. But that's much more than just cookies and trackers and online advertising. That's also email newsletters. That is also contextual advertising. That is out-of-door advertising at the right location. So all of that is part of this discussion, I think, as well, because all of those are also involving personal data. To come immediately to your main question for this panel, is there an effective way forward? I do think there is, but maybe we need to go back to the drawing board to find that way forward, because the current model has become so very complex that it is almost impossible to explain to the individual, to the regulator, to the companies, to follow where all the data is flowing, when it is identifiable or not, when it is pseudonymized, when it is anonymized, when re-identification could be possible, and under what circumstances. We already started that discussion over lunch. It has become so complex that especially the fairness and the transparency are really becoming an issue.
Thank you, Paul. And I think your idea about privacy tech that governs data in a distributed ecosystem is a powerful idea. Thank you. Charles.
Thank you, Sheila. I'm Charles Ping. I'm not quite as anonymous as that picture of me that just said I was private. I'm not that private. I'm easy to find. I'm European Managing Director for a business called the Winterberry Group. We're a management consultancy based in New York. We work only in the advertising, marketing, and data sectors, working with companies and investors to research what's coming and to advise them on what happens next. However, that's not all that I've done. In my earlier part of my career, I was chief executive of a data agency, part of a small advertising agency network. And I was also chairman of the UK Direct Marketing Association and an industry commissioner at the Self-Regulatory Data and Marketing Commission. So and before that, I worked in media for 20 years. So when people talk about the value of advertising to media owners and journalism, I've been at the sharp end of that. When I talk about advising advertisers on data strategies, I've been in that. So I bring a perspective. And also, I'm an Englishman in Brussels in 2023, which is a mildly uncomfortable thing to be when you go through passport control. If I ever mention the word Europe, I'm talking about Europe including the UK, because I still think of it that way, thank you. GDPR is a fabulous piece of legislation. It attempts to go through things in a very principled manner, a device-agnostic manner. The unfortunateness is that it requires elements of testing in courts and through regulators to get the boundaries of how it works. And we're suffering that process has perhaps taken longer than people anticipated. I also am very aware that good law and good regulation both leads consumer and societal views, but also reflects them. You look at the regulation of content in cinemas, and whether it's an 18 certificate or an X certificate or whatever, the boundaries for what's acceptable change over time. And so that is with data and data usage. I come back to the fact that persistently, there is research that shows that 80% of consumers are either pragmatic about how advertisers use their data or pretty unconcerned, and there's 20% that are concerned. And we're here to kind of regulate for the majority, not the minority, is part of my thinking. That doesn't mean the minority have no point or no value, and many of the people who here have campaigned on issues that then become practice in how law's interpreted. But we have to bear in mind that you need to get something that genuinely works. Don't pass good on the way to trying to get to great is a mantra I work for. And therefore, in my view of how advertising works and how marketers have a right to economic success, a civilized economy allows businesses to grow and succeed and communicate to their customers, and customers are allowed to have choice through it. Otherwise, we'd be living in a world that was probably more Soviet in the 1960s, and we don't really want that. So there's a number of complexities here: the right of businesses to work, the right of law to reflect and lead opinions, and how advertisers do things fairly, as Dale said.
Thank you, Charles, for your fabulous perspective, your deep expertise in the industry, and being at the sharp end of the stick, as you say. Gabby?
Hi, everyone. Thank you so much for having me on this panel. I'm really delighted to be sat here next to my esteemed co-panelists. So I'm Gabrielle Robitaille. I'm Senior Digital Policy Manager at the World Federation of Advertisers, WFA. We're the global organization representing the interests of over 150 of the world's largest brands and 60 national advertiser associations. So we represent client-side marketers only. And I'm really delighted to be here and share a little bit more about the brand perspectives on some of this very challenging topic, I think. So our motto, our kind of raison d'être is better marketing. So, of course, we champion brands' ability to be able to connect with consumers, with individuals in more innovative, fun, and engaging ways. But we don't defend advertising for advertising's sake. We really believe that advertising must be carried out in responsible and ethical ways, and in ways which reflect the evolving expectations and needs of individuals as well as society. When it's done in this way, when it is responsible and ethical, we obviously think that advertising is a fundamental pillar to the digital economy. I think everyone knows here that it provides us all with free access to content, news, entertainment, drives competition, helps new and emerging businesses to grow, enables a diverse, pluralistic media landscape, and of course fuels innovation. But we acknowledge today that there is a real trust deficit in the advertising industry, and that advertising is not always working with the best interests of brands or consumers. Right now, I think we are getting something wrong, and there is a tension between existing regulation and advertising and modern marketing. It's why we do see consumers more and more concerned about the way that their data is being used. It's why we see new regulatory restrictions on personal data-driven marketing. It's why we hear lots of references to intrusive ad tracking or surveillance-based advertising. Advertising can't only serve business, it needs to serve individuals and society, and our members only want to really be using data that was sourced in ethical and responsible ways, in line with data protection and privacy regulation. They don't want advertising to fund illegal and harmful content. They don't want advertising to manipulate or discriminate individuals, and it must, of course, uphold the fundamental rights of individuals. And we don't feel that this position is at all antagonistic with regulators' positions. Brands just want to continue communicating with users in a way that is responsible and ethical. But obviously that's not always easy, and that's why it's going to be challenging for us to figure out all the solutions today. But I think ultimately, if we want a sustainable future for data-driven marketing, I think we need to kind of rethink our current ways of working and figure out what is the best outcome going to be for business, for consumers, and for individuals.
Thank you very much, Gabby. We're going to peel our onion a little bit, and I want each of you, from your unique perspective, to talk a little bit about the friction you see. How intense is it? How pervasive, how entrenched, and how does advertising, the friction of marketing and advertising in the digital age against GDPR and Eprivacy Reg, how does advertising friction concerns prioritize against other concerns non-advertising related? Charles?
Shall I start? Right. The friction goes back some years. I remember about 5 years ago when Johnny Ryan was touring the stages of Europe, pointing out how RTB worked and failed for most people, and the data leakage within that world. We were in an environment where there was a whole intermediary layer that was trading data that related to consumers, that consumers had no idea that these companies held that data. And bidding practices were sharing details far and wide. So it failed at that point for many reasons. The fundamental one was that consumers should have a right to know what's happening with their data and the ability to control it. And if an industry doesn't offer those basic constraints, there's going to be friction. Now, that was 5 years ago, and Johnny was doing his presentations, and I sat down with the Chief Privacy Officer of a big global company and had the conversation about real-time bidding and the fact that they were actually capturing the data from consumers who they'd bid low on and failed to win the auction for an advertising opportunity. And you had the conversation that goes, how can you morally pick up the data of a failed auction and put it into your system and consider that a piece of information that you have a right to hold and know about an individual and build a profile? And they tried to defend it. The progress that's happened is, one, they wouldn't try and defend that position now. Two, that position has largely disappeared. Three, we are on a progressive journey to the bigger change in the system that's been flagged for a long time since Google kicked off deprecation of cookies on the Chrome browser, third-party cookies on the Chrome browser. We're moving towards a better situation where invisible intermediaries don't have the right to access data. And if you sit down for someone's house for dinner, the classic test of, am I doing something sensible? And you explain it to the people you're eating with, what you do for a living. If they go, what? Then you know you're doing something wrong. And I think we're getting to a position where the friction between the two is being eased by the progressive move of both legislation and practices amongst big brand advertisers and their suppliers to realize that you can't play the games that you were playing 5 years ago. So we're on a journey, and my characteristic on the friction is there's less of it, it's still around, and we still need to keep working on it.
Thank you, Charles. Paul, you want to jump in?
Sure. I'm not so sure whether there is less friction, to be honest. My friction is mainly on the transparency side of things. When you visit websites that have 500, 600, 700 companies trying to push ads to you, and you have one cookie banner with an accept all or a go to settings button without even the decline all, then I don't feel that I have control. And that user control was one of the foundations of GDPR, of the GDPR reform. It was also intended to be one of the foundations of the new e-privacy regulation, which unfortunately is still stuck in the council without even negotiations happening at the moment. And if you look at users themselves, also they are not convinced that they have control. The Cisco Consumer Privacy Survey of 2022 shows that 39% of respondents indicate they would like organizations to be more transparent in order to gain their trust. 21% would like organizations not to sell or share their data. 43% say they have insufficient control over their data. 25% of users on average decline all cookies if they have that opportunity. Some will say, well, then look at the whole volume of users that are okay with their data being used. And I don't deny that those users exist as well and that it's good that there are data usage also available. I'm not saying we should not use any data for advertising. But it also shows that a lot of users, at least in my view, it shows that a lot of users are unaware of what is actually happening with their data. And that is also why this is a fundamental rights discussion. Fundamental rights are not up for sale. You cannot negotiate them away. You cannot sell them away. So also there, we need to take responsibility as industry, as companies, as advertisers, as regulators, to ensure that the individual is protected.
Thank you, Paul. Gabby?
Yeah, I mean, maybe just following on from what Paul is saying, obviously the digital advertising ecosystem and the supply chain, especially when we're talking about programmatic, is notoriously complex and opaque, and that brings challenges for consumers. How can we ever provide them with the sufficient level of transparency that they can make informed and valid and granular, specifically granular consent? But it's also bringing numerous challenges for advertisers. We've all heard of the so-called ad tech tax, where less than 50% of ad spend is actually reaching publishers. There's research in the UK by UK Advertisers Association that found that 15%, 1/5 of ad spend, is completely unattributable, so that the brand doesn't know where that money is going. We have ad fraud that we have estimated is likely to reach over 50 billion by 2025. That's billions of ad dollars going to siphoned away basically to bad actors. We have digital advertising still funding illegal and harmful content. Advertisers still struggling to get that transparency and understanding of where the ads are being placed and what kind of content that they're funding. And that's why we launched the Global Alliance for Responsible Media, which is aimed at developing the necessary tools and transparency in that area to prevent the monetization of harmful content. And then we have ad measurement. Brands are really struggling to even understand the performance of their ad campaigns because there is just that lack of transparency in the ecosystem. And then to add to that, if we add the fact that the regulatory environment is increasingly complex, we still don't have e-privacy regulation. We have instead a patchwork of different guidances from different DPAs on the use of cookies. We still don't have proper enforcement of existing regulation like GDPR, but add on top of that the Digital Services Act, the Digital Markets Act, the upcoming EU Cookies Pledge, the political advertising regulation. It's an increasingly difficult environment to operate in. And for brands, as I said, that brings numerous challenges.
Thank you, Gabby. Dale.
Okay, so you see what I did there, Sheila. I'd let the guys set out all the issues. So I mean, I think the real pinch points, pain points have been outlined very clearly by the others here. I'm just going to focus on kind of why there's a continuing question mark in terms of, you talk about guidance and regulatory action, because lots of regulatory action is still ongoing. And I mentioned the role of regulators in coming to conclusions on how the law applies, and then the role of courts. And we also see the development as well, which is continuing to drive, I suppose, change and a desire of an industry. You know, I mean, I suppose again the question mark or where all of this lies. If you look at the DSA, is including requirements around not profiling children for personal advertising, which actually aligns with what we published about 2 years ago in our children's fundamentals guidance. So it's interesting to see that we, from a data protection perspective, had come to a similar conclusion, and that's now reflected in the law and in the DSA. But I was going to very quickly just outline to say there will be further regulatory decisions in the near to and midterm in terms of what the GDPR and how it looks like, how it applies in the context of digital advertising and online profile for digital advertising. So very briefly, obviously there's our ongoing investigation into Google Ireland and the real-time bidding system, and that inquiry is looking at processing carried out by Google in the context of its authorised buyers real-time bidding advertising system, and it's examining compliance in relation to the legal basis relied on by Google as collection and retention of personal data, as well as transparency provided to data subjects. And that investigation is now at a very advanced stage in terms of preparing a draft decision for the GDPR Article 60 cooperation mechanism. We've also a large-scale investigation into Quantcast Ireland, and that concerns its processing of personal data in the context it provides to advertising clients to enable delivery of targeted advertising. Again, legal basis issues, profiling, for the purpose of profiling and targeted advertising, whether it's retention of personal data complies with data minimization, the storage limitation obligations, and transparency as well. And then just 3 other large-scale investigations. One is into Apple, and it concerns It originated from a complaint in relation to its processing for targeted advertising connection with the Apple identifier ad ID. Facebook, in terms of its its targeted advertising on its platform, its lawful basis on the platform, and LinkedIn as well, the same on its platform, targeted behavioral advertising. So they're all at advanced or very advanced stages in terms of coming to final conclusions, and I put that in context, submitting a draft decision to our colleagues within the EDPB. So that will drive. I'm raising under this point because I think it adds to somewhat, you can say, the issue around regulatory certainty. But that, insofar as regulators can, we are driving to those points. And I think we can pick up later on what to do in the meantime. But I think it's important to point that out because there will be further decisions from regulators over the coming months.
Thank you so much, Dale. Thank you for a peek into the future and listing out the aspects of these different investigations. These are the frictions, and Paul and Charles and Gabby have added their perspective on friction, which are regulatory, operational, governance, ecosystem, distribution of data, lack of accountability. May I turn your attention to, I want to talk about the elephant in the room. Let's talk about the failures that you've seen from the different stakeholder groups. Maybe the ad tech community, maybe the brands themselves, maybe trade, maybe government, maybe the regs. Let's talk about the failures for a moment and then the challenges that those fails present, because we need to identify the challenges so we can overcome them and get to solutions. Charles, we're going to start with you.
Right, okay. We don't want to get in the pattern of it starts with me, and we can move it around a bit. But the biggest failure is probably the cookie pop-up. That if you want to get some kind of consent from a consumer, having something that they go blind to after the first day is achieving nothing. It's interrupting a transactional journey. It's not getting anything meaningful because we all know the behavior we display when we see those things. Actually, this room is probably full of the people that click the other thing and look at the, but if it was a normal room of a couple of hundred normal people off the street, you'd probably find 2 of them that click the more information box. The rest of them just click the yes. That's a failure of the industry and to work out how to inform and engage with consumers. It's also shown that if you remember back to 2018 when Cambridge Analytica was in the news and Mark Zuckerberg got dragged to Washington and forced to sit in front of the House of Representatives and be questioned. After that, Facebook bought in, if there's anyone from Meta in the room, you don't have to identify yourself here, but talk to me later. Facebook bought in a functionality that allowed you to stop tracking off the Facebook platform. And it's actually, unlike a lot of the privacy controls within the Facebook platform, it's not hard to find. And it's a one thing, and it stays permanently that way. When the CMA in the UK looked at the usage of that, their banding was between 0 to 5% of users had bothered to activate that. So you've got the kind of Schrodinger's cat of privacy here, that consumers are both bothered about it and not bothered about it at the same time. And the biggest failure of everybody in this room and everybody, be it in Silicon Valley or New York or London or Paris, is working out a way that we can meaningfully communicate the value exchange that they get from advertising or content, whilst maintaining their ability to exercise their right to understand what's happening, say yes or no, know how long it's going to be kept for and for what purposes. Those kind of basic tenets of what goes on. And I think we're no further on now, 5 years after GDPR and however many years after the Eprivacy Directive that effectively gave birth to cookie pop-ups. We're no further along. That's our biggest failure.
Thank you very much, Charles. Dale?
Yeah, I jump in here. Just a few observations. I think, first one I wanted to mention is it relates to the e-privacy regulation. I don't want to term these as failures because, there's a process underway, but the new regulation, we continue to work under the existing e-privacy regulation, which means it's implemented in each member state in its own particular way, which hasn't helped a common harmonized approach to issues like capturing consent for cookies across the member states. Now, the DTB has worked hard to try and bridge some of those gaps, but nevertheless, how the law is implemented in a number of our member states leads to still differences in approach, and that's somewhat unavoidable, unfortunately. So I think that's one of the missing jigsaws, although that's not for me to critique. Really, it's the legislators have to bridge that gap. But from a practical regulation as a supervisory authority, it does lead to challenges. And I know it leads to challenges for industry too in terms of what's the position. I do think, though, on an issue such as consent, we are bottoming out on what that looks like in an e-privacy context, but it would be helpful for a harmonised European law to bring us all to the same place. Did you want to ask a question, Sheila?
Yes,
yeah. Oh dear.
So for you have a unique view. So for the companies you've looked at that must comply with the Eprivacy Directive across multiple states versions, have you seen companies comply differently on a country-by-country basis?
Not for the big tech platforms, no. They do try the one solution generally for all.
Highest common denominator, if you will.
But I think that's been evolving quite a lot over the last number of years. If you went back 3 or 4 years or 5 years and looked at how consents were collected for placing of cookies, it's radically different. Now, I mean, I'm not going to say whether it meets entirely the standard or not now, but it's radically different from what was being done back then. So there has been a huge shift, but that's at the surface level, and there is that question of what happens beneath the surface, particularly in the digital advertising space, and like real-time bidding and so forth. But there's one other point I want to make on this as well. There's the concept of the privacy paradox, where. And what leads individuals to say we're concerned about our data protection, our privacy rights, but yet not exercise those rights? You touched on it, Charles. And I don't think it's fair just to say it's because there's different motivations. Some may be quite happy, others. But perhaps we need to think a little bit more reflective and deeply on, have all of the stakeholders with a say in this helped the person on the street to really understand why this is important and what it means, other than to say, I keep getting hit with ads, and I don't know why, and I'm confused. And that's where a lot of people are. You talked about at the dinner table what people try to explain, and they say, well, more when I try to explain what I do as a job, they kind of go, what? But anyway. But so there's an issue we need to reflect on. And there was a Dutch report done in the Netherlands a few years ago, which looked at this question. And it just was one line in which I've enjoyed, which I think was quite important to think about. It just says, imposing a legal framework to protect personal data without a deep understanding of the function of data in society does not work for users and leads to frustrations and unintended consequences among the public. And I think this is the challenge for modern marketing, digital advertising, is to say, and perhaps a failure as well, and I don't want to point fingers at anyone, but industry as well, can we say they've fully stepped up to the plate to look at where the individual fits, and others have mentioned this, where the individual fits in this, and is what is happening really understandable to individuals? Is there an element, is there user control as required by the law? And what else can be done to really help strike, as I talked about earlier, the fair and proportionate balance in terms of the role of business, the role of advertising vis-a-vis then that really important role of the individual and the rights of the individual.
I think those are very important points, and at the risk of taking us down a birdwalk trail, there was a piece of research done in 2008, a long time ago, that studied the issue very pervasively, and it said that people actually don't want to control the data themselves. They don't want to sit in front of a NASA-like space station control panel and control all the nuanced uses of their data. What they actually want is data to be under control, used accountably for their benefit. So we do have that reality to grapple, and the privacy paradox, that we talk about all the time reinforces that. And then we all have very busy lives as people. We're professionals, we're consumers, we're parents, we have aging parents of our own to deal with, we're community participants, we have charities we love, we have busy lives. So how interested are we as people, or do we want to be able to trust the brands and the ecosystem and the advertising? But let me turn now to Gabby for her thoughts on the fails and the challenges, because clearly we're surfacing many that maybe not all of them, but many of them, the ones that are at the very top. So Gabby, thank you.
Thanks, Sheila. I wanted to follow up actually on what Charles was saying about how he thinks that you think that the biggest failure is the cookie consent notices and balance. It's a failure.
To get consumers to engage.
Yes. Okay. I personally think that there's a bigger issue where right now we're operating in an ecosystem which is serving the interests of those that have a fundamental stake in maintaining the status quo, and we're not putting what the consumer really wants at the center. And I know we've had lots of references to lots of different pieces of data, and I'm sorry that I'm about to add to that. But the European Digital Advertising Alliance last year conducted a very interesting piece of research that it wasn't just, it's not about stats, it was having a conversation with them. It was opening a conversation with users about their online advertising experience. What were their frustrations? What did they like? What didn't they like? And what were their expectations for the future? And I do want to just take a moment to take you through some of those some of the findings there, because I think it's really important to this conversation. So it was an online conversation, over 3,000 participants from France, England, Germany, Latvia, and Belgium. But there were over 16,000 contributions, so things like likes or comments were left. It was all done via a platform. So it'll be no surprise to anyone that many users reported a sense of frustration with their online advertising experience, that they felt overwhelmed by the number of ads that they saw, overwhelmed by the impression that they had about so much of their personal data being used, real concerns about surveillance, misuse of their data, felt like the advertising industry wasn't respecting their personal data, that it was being stolen or used against them, that lots of sentiment of being scammed. And we spoke about that, Charles, actually at lunch, about sometimes you get the feeling that the ads that you're seeing are scam ads. And this perception of unfairness, that they feel like they have to routinely surrender their data for advertising purposes. And what was quite interesting was, despite this feeling that so much of their data was being used, they didn't feel that their ad experience was that relevant. So they talked a lot about relevance. So I don't feel like the ads I'm seeing are really that interesting to me, or they don't really expose me to new services and products, or actually help me in making decisions, which is the fundamental of advertising, right? So what did consumers say that they wanted? There was, of course, general recognition that, yes, we need advertising, and that it's necessary to fund our online economy, but what they want is more relevance. I'm not going to sit here and tell you we need more personalized and hyper-personalized advertising. What we need is more relevance. They don't want to see the same ad over and over and over again. They want advertising to be helpful, to expose them to new products and services and deals, and they want to feel, above all, that their data is being respected. And I think that is a fundamental starting point as we think about how is the industry going to move away from third-party cookies and trackings. Are we all going to go to fingerprinting and UIDs? Well, I mean, it's a cookie, but it's dressed in something else. So, let's look at what the consumers are telling us, and let's think about what is the way forward. Maybe part of that is contextual. Maybe it's first-party data. Maybe it's data clean rooms. There are loads of technologies that are being developed right now to address the deprecation of third-party cookies, or doomsday, as some people refer to, in a way that will respect consumers. And I think that the industry has a responsibility to capitalize on that and to propel those kinds of models.
I think that's absolutely right. I think fairness, respect, and value exchange is very important in the advertising space. Trust is the most important piece of work that we do, is to protect and preserve, to build and honor. Paul, if I may turn to you.
Sure. Data protection by design, that was indeed also one of the things that I had listed for this specific part of the discussion. You mentioned the industry is developed with the interest of the industry in mind and not the interest of the individual. And again, we are dealing with a fundamental right that we need to protect. So the individuals should be front and center. And of course, it is important for companies to be able to also show advertisement, but then maybe also look more at the traditional models and maybe satisfy ourselves that we cannot, for every single ad that we place, have an exact calculation on what the return on investment should be. Because contextual advertising, there are reports that show that actually it is 30% more effective than the targeted advertising that we currently do. It's only a handful of studies so far. There should be more, but let's also look into that. The other failure on my account, I think, is the confusion between the legal basis. When do we ask for consent? When can you use legitimate interest? I'm not going to advocate here that legitimate interest should be part of the e-privacy regulation. I've very well heard the words of Birgit Sippel, I think it's 4 years ago now at this conference, over my dead body, that will ever happen, and I still agree with her. But there are also direct marketing activities that you are able to do on a legitimate interest basis if you have an existing relation with that customer. However, I also come to find that for a lot of the online marketing activities and also ad-driven technologies that are out there, there is a confusion on the side of the bigger platforms, especially on using data that was shared with them on a legitimate interest basis, also, for example, for matching with new audiences, which clearly requires consent. And there is no option to make that distinction. So also there is a big responsibility in all of us to make our fundamental, or the legal basis clear for ourselves, and also make those distinctions possible in the whole industry that we are developing. Because also as a company, we do need to have those advertisements because we want to build new customers.
Thank you very much, Paul. I just want to have each of you briefly reinforce a point that I grapple with every day, and that is, if there is to be an economy where we all have jobs, there has to be businesses which have to have customers to exist. To have customers, you have to be able to efficiently attract and retain those customers, to have them. So how critical is marketing and advertising to the European economy?
Massively critical. It is the engine that drives economic demand and growth. However, that doesn't mean it has a primacy of its rights over any other rights. It has to coexist. And in thinking about individuals' rights and technologies, the right of a business to, within the boundaries that the lawmakers and the opinion formers and society, the stakeholders, I suppose, in the game, think are fair, it has to operate. If in a perfect world, any brand that operated outside those rules would have a negative impact on its economic welfare. I'm not entirely sure that markets work quite that perfectly some of the time, but yeah, it's undoubtedly critical, and you don't want to get into a supply-driven world of economics. You need demand generation.
Paul, let me go to you.
Yeah, no, I fully agree. Advertising, online marketing is important. I work for a scale-up. We need to develop brand recognition. We need to develop our market, and we cannot do that without also being able to reach a new audience. For all of you, that's Catawiki.com. But I can't go to every single individual in Europe and tell them to come and visit our website, register for an account, and start bidding on the objects that they love. So we need advertisements, and we can do that the traditional way in magazines. We can run TV ads and radio ads and host events, but we are an online platform, so that means we also need online advertisement. But we need to do it right, and we need the infrastructure to be much more transparent than it is today to be able to do that.
Thank you very much. Gabby?
Yeah, I mean, I completely echo what has already been said. Of course, it's critical to the economy, but I just think that, you know, today businesses are expected to go beyond delivering on financial performance. They're supposed to demonstrate a positive impact on broader society, and I think that extends to the way in which they conduct their marketing. So yes, I completely agree, but it needs to be done. It's not advertising at all costs. It needs to be done with the right intentions.
Balance. Dale?
So, I think I come from a supervisory authority, and when you're applying the law, you don't obviously take into account commercial considerations, and the DPC never takes into account broader. We acknowledge the context in which we operate, we acknowledge the industries we regulate and the complexities of them and their place, but we don't make decisions, either formal or informal, on economic related matters. And actually there's a broader context why that's important for me to say that, because often it's an allegation that's made at the DPC in terms of how we regulate the tech companies in Ireland. So quite a little bit off topic, but it's important to note that we regulate what we believe the law requires us, and the decisions we reach is what we believe the law requires. But I do want to draw out one quick point, and that is trust in data stewardship. And the GDPR is about that. We're there to protect the right to data protection, and the obligations then on the other side that are placed on organizations to comply with the GDPR, ePrivacy, and any other regulation in a European context. It ultimately all comes back to users' trust. And if you don't have users' trust, do you have a sustainable industry? And that's all I'll say about that point.
Competitive markets are trustworthy markets, I would argue. So now we're going to turn our attention to the effective way forward. We have talked through, and I've tried to capture most of them, the fails, if you will, the challenges, the frictions, cookie pop-ups, the Eprivacy Directive, plus DSA, DMA, and political, the patchwork, the cookie consents bottoming out, the privacy paradox. The people are overwhelmed. They feel surveilled. They're worried about misuse. They're worried about fraud, theft. Want their data respected, and that there are alternate means to personalization that may work. I think that you need to read the Howard Beals, Andrew Stiver's NARA research, which is very interesting research that says the economics of going purely contextual removes 70% of the revenue from the marketplace, and free speech and democracy are ad funded. So if you take 70% out, guess what it kills off? It kills out all the small businesses, all the medium businesses, and publishers. So it's a delicate equation, and we've got to look at all the research. But I see Charles getting ready to jump in, and I want to get, because this is hard. We can talk about the challenges, the frictions, the failures, and we are all very immersed in that and very worried about it. And for those of us that practice this for a living, that apply these constructs to a highly complex ecosystem in service to clients and in service to people to build that trust, protect that trust, be respectful stewards of data, is there, as I said in the open, is there a way to throw out the bathwater without throwing out the baby? Is there an effective way forward? Your best ideas. Let's spend a little time on that, and then we'll open it up for questions from you all. Who wants to take the first best ideas for an effective way forward?
I'll start.
Dale.
Yeah, Sheila, because I perhaps you mightn't agree, but the regulator isn't going to find necessarily the solutions. We'll just apply the law. You might not necessarily like that, but that's largely the reality of it. Obviously, it's more complex than that. But part of the solution will be continuing clarity from the regulators on what current status of what the law means, what the GDPR, ePrivacy, etc. means as it applies, and we're driving to deliver those conclusions in our work at the DPC. But there is one thing I'd just like to draw out for further, and I think is worthwhile further reflection. How can industry work cohesively? to find solutions. I do believe, from what we see, part of the problem to date is, first of all, a system which is, many have mentioned, very difficult to understand, is quite opaque, and leaving aside the whole issues that has for users, but also industry, is it coherently trying to address, or are there pockets within the industry that have their own agenda while they're in the same ecosystem, are not necessarily working together? And I say this in the context of what, there's tools within the GDPR around codes of conduct, certification. There's lots of things that could be looked at. They're not easy. It'll be a hard road to get to it. But I think solutions in this space need a common standards, harmonized standards that all players are held to. So, and the benefit, if you can do it through a GDPR prism, is that it has to go through the regulators, and a pan-European code will obviously go to the European Data Protection Board for its assessment and approval. So that's one idea, perhaps, that industry can bring to the table to say, what can we do, looking at all of the things that are on the table. I say that fully acknowledging this is very complex. Technology is moving fast. There's different technologies, different approaches, not even agreement on which is the best way. So perhaps it's a little simplistic for me to say it, but I think it's worth reflecting, because what's happening if we don't, we have disparate views, bad actors within the system, and I think as well as the regulatory oversight, which has to be there and has to make hard decisions with potentially enforcement action. The GDPR envisages that level of self-regulation through codes, through certification, and I think there is potentially something to be looked at in that space.
I'm so glad you brought that up. Most of us spend so much time dealing with trees that are on fire. We forget about the forest. We can't see it, and I'm glad you pulled that up. I'm going to give that a think, the codes of conduct. That might be very exciting. All right, great ideas.
I can go next.
All right, Gabby.
I think I'd agree that we need more harmonized and cooperative enforcement. I think it might be good to reference the AdTech study that was published by the European Commission at the beginning of this year, which did note that since GDPR came into force, we actually haven't seen a significant change to the nature or quantity of data processing. And a lot of the enforcement action has focused naturally on some of the biggest players and intermediaries, and that for that reason, we actually haven't seen the full impact and potential of the GDPR and existing regulation that we have already. So I'd encourage, yes, more harmonized, better enforcement of existing regulation. We also need to maybe have an e-privacy regulation. I think that would be quite helpful, actually. An e-privacy regulation that, of course, protects the privacy of individuals while protecting business critical purposes, like I mentioned, the ability to identify ad fraud or ensure ads aren't funding harmful content or measure the performance of ads. And then, of course, I think there's also, I mentioned it earlier, there's a responsibility for the industry to look towards developing alternative models of digital advertising, which are less reliant on third-party tracking, on third-party data, and which better meets the needs of individuals.
Thank you very much. Gabby, those are great ideas. I've tried to capture them. We'll circle back. I'm going to capture more of those. Paul, do you want to go next?
Sure. I think, first of all, privacy by design and privacy by default needs to be taken much more seriously across the industry. By the companies that want to serve ads, by the consent management platforms, which are not set to privacy-friendly settings by default, by the advertising industry behind that. I think that we really need to start thinking consumer first. It is a legal obligation, but it is also the ethical and the responsible thing to do. We get additional obligations under the DSA, DMA also to move away from dark patterns. So that is a very important one that will kick into effect early next year. So we all need to start preparing for that today, or actually yesterday. I agree with Dale that codes of conduct certification mechanisms could be helpful here. and maybe some consolidation in the ad tech industry would also not be too bad. We should not have a duopoly with just Meta and Google serving all the ads and running all the ad platforms. But again, having 700 different ad platforms on your website might also be overdoing it. So somewhere strike a balance, somewhere in between might actually also be good. In the ideal situation, I think we should go back to the drawing board, but I also recognize that that is not a realistic option. But we should, all of us, make much more of an effort to ensure that the model that is currently being used becomes much more compliant and much more transparent.
Thank you very much, Paul. Great ideas. Charles.
Okay, I've got a reasonable list here because I think no, I said a reasonable list, not a long list.
How much time do we have here,
yeah.
Charles?
Shush, Dale, shush. To throw the bathwater out without the baby, there's a number of components, but I don't claim to be the chef that knows the recipe. I know the components. We had a very good discussion yesterday around legitimate interest, and legitimate interest has the benefit that if it was applied correctly, it would clock in the consumer's mind and go, yeah, that makes sense. However, I've never seen a legitimate interest impact assessment that wasn't written with a bias of one perspective or another. So we need to find a better way of doing that. And I'm not just saying that because part of the UK's minor divergence from GDPR puts legitimate interest into a stronger place. I would think that even if we weren't doing that. I noticed earlier this week, or was it late last week, Google committing to its timeline for third-party cookie deprecation. And the Privacy Sandbox APIs are going to be available from late July. They claim that they're getting to within 1% to 3% was the range they quoted in performance for compared to identity-driven advertising for the Privacy Sandbox approach that doesn't use identifiable personal data. I'd like to see the maths behind that and the workings, and I've asked Google for that. If anyone from Google in the audience can provide that, that would be brilliant. But I guess by Q4 this year, and certainly by this conference next year, that point will either have floated and be working, or it won't work. Pseudonymization. 2 years ago, I wrote a paper on pseudonymization and data collaboration. And it was probably a time when there were very few people outside of the kind of people who are in this audience who knew what it meant or could pronounce it properly or even spell it. I don't think Microsoft still spells it correctly, but that's part of Word for you. I think that more sophisticated approach of pseudonymization is part of the key to future success of maintaining consumer privacy whilst maintaining targetability. I maintain that whilst we're all individuals, we actually behave in groups. You look at the way people dress here and all sorts of things. We all behave in groups. So group-based targeting should be able to perform as well. It's just the components of it are difficult. I think Meta has shown an interesting way forward. Meta gets a lot of stick a lot of the time. Some of it, I'm not going to look at Dale at this moment deliberately. Some of it rightly, some of it wrongly. But their conversion API for judging performance has been acknowledged by the advertising and marketing industry as a pretty good solution to a difficult problem. So Meta showing the way that you can provide solutions that meet an industry need without personal data going outside the world. The second last point I'll make, because I can feel Sheila burning into my head here. Apps Flyer measure a lot of stuff around apps, and when the iOS 14.5 changes came in and all the app consent came into iOS, we all thought it would be the end of the world for it. Now, the latest stats show that for non-organic app installs, so app installs that have been driven from marketing communication, as opposed to just browse the store, the level of first-party data matched to those apps is running at 26-27%. It's up 10% from last year. That's the average figure. Bear in mind there's some shabby apps that you'd never give consent to in there, and there's some really good apps to do with retailers you want to have on your device. The better brands are going to be getting way north of 50% opt-in. So Apple's move towards privacy and some really consumer-centric commentary in how they do it doesn't necessarily mean the end of the world if brands understand how to utilize it. And so it's a mixture of all those components that are going to help us create a way of throwing the bathwater and keeping the baby, as Sheila says.
Thank you very much, Charles. I think that the solutions themselves highlight the complexity that we've been walking through. We do have a few minutes saved for any questions from the audience. Yes? You want to get Marty a microphone?
I'm Marty Abrams. I am the Chief Strategist at the Information Accountability Foundation. This is the third session today I've listened to that had something to do with the digital advertising environment. And in none of them was anybody ever very happy about anything. So, and it is an issue that I've been looking at since 1995 and seeing structure built on structure, built on structure, built on structure. When I listen to this panel talk about some of the solutions, is it possible that we really do need to think about zero basing when we go to thinking about codes of conduct, when we think about what are the privacy interests that are in play, what are the commercial interests, rather than, because all of you propose things that sort of go below the current structure and try to build up. So I'm just asking, is it really unrealistic to say that maybe we should do some zero basing here based on, you know, the key interests, the key players, the key components of privacy when we think about how to solve this problem over time?
I like the idea of zero basing. I think it goes to the notion of, can we develop a harmonized code of conduct, code of practice, and get agreement amongst all the components of the industry sector, the brands, the technology providers, and the regulatory community, and the other NGOs, let's say, the people, the full stakeholder interest. I like the idea. Do you guys think it's possible?
I leave that to the experts here. I was just going to make one point. In whatever needs, I think there's that reflection back on the basic principles. So from our world, it's the GDPR, primarily those Article 5 principles. That's at the heart of, and all that goes with it. So when you're talking about how do you really create an ecosystem that respects data protection law, that's at the center of it. And yes, there'll be debate and discussion as to where the boundaries fall. But if you got, I mean, you know, again, it's kind of slightly utopian maybe in where things are at the moment. But that's what we got to do. And that's what regulatory, I think, decisions are going to drive back towards, is where how these principles have been applied. So one way or another, if industry doesn't want to move, I know, and I'm not casting everyone in industry, obviously, but if that's not the focus when it comes to data protection, regulators are moving because our investigations are ongoing. They will conclude and determinations will be made, and they're done in the cooperation process in the context of the EDPB. So one way or another, there is a focus back now on what does compliance with the law require. So I think there's a space, there has been and continues to be a space for industry to also see what it can do on, within its powers, as well as their individual compliance of organizations. That doesn't go away, of course, but I'm talking about in a more holistic industry-wide sense.
Yes, a harmonization across different stakeholder groups. We need a convening. That's what we need. Charles?
Marty, don't go there. Don't go there. Think how long it's taken Eprivacy to get somewhere. And there was a comment made in one of the sessions this morning that in GDPR's origination, the trilogue phase corresponded with the Edward Snowden revelations and things, and that kind of turbocharged the need and the commitment to create a policy. I think it's back to the don't pass good on the way to try and reach great. We have to work within the framework we've got, because my life expectancy probably isn't enough to see another GDPR arrive.
Thank you, Charles. Paul, from you, and then Gabby, did you want to jump in on this one, or should we go to another question? Okay, go, Paul.
One sentence for you, Marty. If the foundation of the house is unstable, you better invest in the foundation before adding a floor.
Good analogy. We had another question somewhere here.
Yes, and it's along the same lines. My name is Bert. I work for a publisher here in Belgium and the Netherlands. So on the sharp end of the market, the supply side for sure of the market, we have a lot of good intentions. We're trying to build an ecosystem that's sort of walled, where there's no data leakage, so we can hold up our privacy promises to our users. And we, of course, try to work with advertisers directly who also have a lot of, granted, really good intentions to develop a more responsible ecosystem. But what we see in reality as well is that your ad spend on the demand side flows a bit like water, and it flows to the big oceans of the platforms as well, despite all the good intentions. And very concretely, for example, UIDs was mentioned, universal identifiers. For those who don't know, it's replacing cookie IDs with hashed emails to track people across the internet. Is a no-go. I saw people agreeing on that on the panel. In reality, we see that in the market that's gaining a lot of traction, and that we are losing money because we say, we agree with you, it's wrong, we're not going to participate. So my question is, isn't it time to leave this consumer-first and consent-based paradigm and to start thinking indeed about other solutions whereby we outright ban certain things, like we do in regulation in other markets? Paul can be recused from answering the question because he already said over my dead body, but I'd love to hear from everyone else.
Sorry, I missed the last bit of that question.
Yes, we have 5 minutes.
What was the
Yeah.
question? What was the last part of the question?
Legitimate interest.
Should we ban certain things, certain ad practices? It would depend what we're talking about.
Do you mean, let me just clarify, do you mean the balance of Article 7 and 8, I think it's 7 and 8 in the Charter with Article 16?
I would say forget about articles in the current legal framework. Shouldn't we move away from this paradigm where we place the onus on the consumer to understand what's going on, to consent to it in a certain way? And shouldn't we just say, like we say, Americans, we don't want your chlorine-washed chicken on our plates, right? Shouldn't we in the same way say there are certain advertising practices that we do not allow and we ban it through law rather than having consumers decide whether they want it or not?
Do we? Sorry.
Go ahead. Sorry.
We do already see that happening with the Digital Services Act and the Digital Markets Act, and we haven't had those laws implemented yet, so we don't know whether they will have an effect. But yeah, there should be certain ad practices that are banned.
So the question of prohibitions is a question for the legislators, obviously. But let's not forget that there's positive obligations on every organization from a data protection point of view. I mean, yes, there's different standards of compliance, but fundamentally, every player in the ecosystem has a legal obligation to assess what they're doing. Now, they may not be doing that, so it's regulatory action then that has to find those. And I want to make the point, every supervisory authority in Europe has a role to play here because these players are placed across Europe. But in terms of user-centric, when I talk about user-centric, I'm not focusing on just consent and control and all. It's actually much more than that. It's about that data stewardship. It's about the proper assessments being done by the organizations. I liked what Charles said about legitimate interest impact assessments because I kind of agree. They're very poor in terms of their quality. There's so much more to be done. If that was done right, if you had proper assessments of setting aside the lawful basis, consent, and all the rest, but just simply that deep looking at what do we want to process data for? What's the purposes? Why are we doing it? What's the rights of the individual? What are the risks? What are the adverse impacts? All of those things brought together in a really proper way and genuine choices made. You would have then that is a user-centric approach because the user is at the center of it, with that balance then being found, between the economic imperatives and what that fundamental right of the user is and where that balance is struck.
I see Charles wanting to jump in on this one.
I think there's an argument with legitimate interest that any entity that stands to benefit from the outcome of the legitimate interest shouldn't be part of the evaluation of it. I made the point at lunch and I had to explain what Dignitas was to Sheila because she's American, that the Dignitas clinic for assisted suicide in Switzerland, the person that takes you there cannot benefit from your will because otherwise my children will be getting me there next week or whatever. But there's a very logical point. You should put a standard in place as to how this works because I've seen too many sales departments writing legitimate interest impact assessments and media owner, would you let your ad salespeople write the LI? No, of course you wouldn't because they're incentivized the wrong way. There's a better way forward and it's not difficult to get there. We just have to have a slightly different way of thinking.
Well, I'm going to let that conclude us. We're at time. I want to thank you all very much for your attention, for being here, for listening, and we welcome any and all feedback and ideas that you may have. United we stand, divided we fall. We need a balanced economy, and we need to do right by people. In the immortal words of Giovanni Butarelli, data should serve people. Thank you all so much for being here.